This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why one should never drive a stolen vehicle in view of the owner, and why conviction for possession of a stolen vehicle will stand, and why it is strange that a convicted felon would appeal such a gentle sentence provided to her by the court. Jennifer L. Martin appealed her possession of stolen vehicle conviction, arguing that the allowed testimony violated the Confrontation Clause of the U.S. Constitution, and the trial court erred in denying her hearsay objection during trial. The state conceded that it failed to prove Martin's criminal history, and in so doing, allowed Martin to allege prosecutorial misconduct and ineffective assistance of counsel. In State of Washington v. Jennifer Lorraine Martin, the Court of Appeals of Washington on July 9, 2024, affirmed her conviction. Pierce County Sheriff's Department dispatched Deputy Carly Capetto to investigate the report of a stolen vehicle. The vehicle's owner reported that he spotted the vehicle and followed it to a U-Haul store. Capetto was nearby and also observed the vehicle pull into the U-Haul store. Capetto observed Martin get out of the vehicle and walk over to a U-Haul truck, and Capetto approached the vehicle and confirmed that it was the stolen vehicle by checking the VIN number. Martin was aware of Capetto's presence and kept looking over at her. Capetto observed Martin get into the U-Haul truck and drive through an alley. Capetto followed them and waited for backup. Stopped at a nearby grocery store, and Capetto observed Martin get out of the truck and go inside the store. A store employee approached the deputies and told them the individual they were looking for was in the restroom and had been in there the whole time. Capetto located Martin in the restroom and arrested her. The state charged Martin with unlawful possession of a stolen vehicle. During trial, Capetto testified to the events that led up to Martin's arrest, and while testifying about looking for Martin inside the grocery store, Capetto stated that a store employee approached the deputies and said, quote, "The female they were looking for was located in the bathroom, and she had been in there ever since she came in," close quote. Defense counsel objected, stating, quote, "I object to her reporting hearsay from the store clerk that we can't examine," close quote. The trial court overruled the objection. The jury found Martin guilty of unlawful possession of a stolen vehicle. At sentencing, the state only summarized Martin's criminal history without providing evidence. Martin conceded that she had a prior felony conviction for escape, but argued that it had washed out, whatever that means in Washington state, meaning it was no longer a real conviction. The trial court concluded that the prior felony did not wash out and calculated her offender score as a 1. The court imposed a low-end standard range sentence of 2 months, and the court ordered Martin to pay $500 in restitution to the vehicle's owner for damage to the vehicle. Analyzing the issues, the Court of Appeal first dealt with the Confrontation Clause. Neither a general objection to a hearsay statement is enough to apply the constitutional right to confrontation of witnesses. During trial, Capetto testified that while looking for Martin inside the store, a store employee approached the deputies. Additionally, Martin raised the issue of confrontation previously in her motion to suppress Wright's statements, and in so doing demonstrated awareness of the issue and ability to specifically raise it, but did not. Martin also dealt with an issue of hearsay, contending that the trial court abused its discretion in allowing Capetto to testify to the grocery clerk's statement. Hearsay is a statement other than one made by the declarant while testifying at trial, offered in evidence to prove the truth of the matter asserted. Generally, hearsay is not admissible unless an exception applies, and an exception for present sense impressions and the declarant's availability is immaterial. A store employee approached the deputies and told them Martin was in the restroom and had been in there since she came in. This statement was made within minutes of the deputies starting their search for Martin and was based on the store employee's observation of what was happening at the grocery store. The contemporaneous and spontaneous nature of the statement, including the timing, nature, and content, reduces the chance of misrepresentations or fabrication by the witnesses. Therefore, the statement was a present sense impression and an exception to the hearsay rule applied. The court therefore affirmed Martin's conviction, but accepted the state's concession regarding the sentencing error involving proving Martin's criminal history and remanded the case for resentencing, where she, with her prior felony convictions, might end up with an even greater sentence than the 2 months. In my opinion, criminals like Ms. Martin have, by definition, chutzpah, or they would commit crimes. Ms. Martin, caught in the act operating a stolen vehicle when the owner can see her and call in the sheriff's office to arrest her, is less than an act of a wise person. She was caught in the act, arrested, and then had the unmitigated gall, the chutzpah, to appeal based on non-existent objections and misstatements of the hearsay rule. Her sentence was kind, only 2 months, and a reasonable person like Martin, with a criminal conviction history, including escape, should have accepted the sentence and left the court to deal with serious crimes like insurance fraud. This video was adapted from my blog, Zalma on Insurance, and is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,800 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.